I had been watching American politics long enough to recognize when something did not unfold in the usual way. This time, it was not the headline itself that caught my attention. It was what followed the headline. The networks reported the decision, and then something unusual happened. There was a pause. Panels did not rush in. Allies did not immediately flood the airwaves. Phones rang, but the noise level stayed low. That kind of hesitation is rare. Normally, when Donald Trump loses a legal fight, the response is immediate. Statements appear quickly. Lawyers step in front of cameras. Supporters fill the silence with noise. This time, there was a delay, and it was noticeable. I stopped and paid attention. That pause mattered, because in this system, silence is almost never accidental. To understand why this moment felt different, it helps to understand how situations like this usually unfold. High-profile legal setbacks are normally absorbed into the political rhythm. Appeals are hinted at. Procedural options are left slightly open. Even a loss can be framed as temporary, especially when the case reaches the level of the Supreme Court of the United States. When the court wants to slow things down, it knows exactly how to do that. When it wants to leave room, it does so carefully and quietly. That is the baseline behavior. This situation did not follow that pattern. The order itself was brief and direct. The language was clean and firm. There was no soft phrasing. There was no invitation for additional briefing. There was no procedural off-ramp and no suggestion that another filing might clarify the matter. There was only a deadline. That alone was unusual. What stood out even more was what was missing. There were no dissents. There were no concurring explanations. There was no internal debate aired publicly. When the court moves in that way, it usually means something significant has already taken place behind closed doors. I noticed that immediately. The issue itself was not new. It had not suddenly emerged. It had been moving through the legal system for years. There had been subpoenas, appeals, and delays following a familiar rhythm. Since 2019, investigators had been seeking financial records connected to Trump's business operations. These included tax filings, accounting documents, and internal records held by third parties. Every step forward was met with resistance. Every order triggered another filing. Every deadline was stretched. That strategy had worked before until now. What changed was not the substance of the request. The law itself had not shifted. What changed was the court's tolerance. The justices described the latest filing as raising no new arguments. They stated clearly that the claims had already been rejected, and not just once. That phrasing was deliberate. Courts expect losing arguments, but they do not tolerate repetition without purpose. I had seen that language before. It usually appears right before enforcement hardens. Enforcement is not something the court discusses lightly. The most revealing element was not the legal reasoning. It was the reaction that followed. Trump's legal team did not go on offense. They did not preview a next move. They did not project confidence. Instead, there was another pause. That was the second one. When pauses begin to stack, it signals that the usual playbook is no longer working. To understand why this mattered, it helps to slow down and examine how high-profile cases usually operate. When a case involves a former president, the system typically moves with caution. Deadlines are flexible. Language is careful. Enforcement is implied rather than stated. Everyone involved understands the stakes, and restraint becomes part of the process. That restraint was missing here. The timeline itself was important. The subpoena requests dated back several years. The records were not demanded suddenly or without review. They were pursued through standard legal channels. Lower courts examined them. Appeals were heard. At every stage, the conclusion was the same. The records were lawful to obtain. What changed over time was not the law. It was patience. By the time the final filing reached the court, the arguments were familiar enough that they no longer required explanation. When courts stop explaining, it usually means they believe the explanation phase is over. That shift stood out immediately. The filing was labeled an emergency request. That label attracts attention, but it also brings scrutiny. Emergency filings are expected to present something genuinely new, such as a new harm, a new legal conflict, or a consequence that cannot wait. This one did not. According to the order, it repeated claims that had already been rejected. That was not a technical criticism. It was a behavioral one. Courts remember behavior. Once a court concludes that filings are intended to delay rather than resolve, the process tightens. Deadlines stop bending. In this case, the deadline was precise and unambiguous. The records were to be produced by third parties. including accountants and custodians. That detail mattered because it removed a layer of interference. The order did not ask for cooperation. It required compliance. It also explicitly warned against obstruction. That kind of warning rarely appears at this level unless repeated problems have already occurred. The language around contempt was especially revealing. Both civil and criminal contempt were mentioned, without softening. Civil contempt is meant to coerce action. Criminal contempt is meant to punish defiance, even if compliance later occurs. Courts do not spell out that distinction unless they are prepared to use it. This was not speculation. It was instruction. Inside legal circles, an order like this changes conversations quickly. Lawyers stop discussing strategy and start assessing exposure. Once contempt is on the table, options narrow. Partial compliance becomes risky. Public defiance becomes evidence. Delays become intentional acts. Publicly, there was no outrage. The tone was restrained. Statements were measured. Allies avoided specifics. Media coverage stayed factual longer than usual. That was another signal. When people do not rush to fill silence, it often means they do not yet know what to say, or they know and are not ready to say it publicly. Behind the scenes, pressure began to spread. It did not stop with the central figure. It reached lawyers, staff, and third parties such as accountants and custodians. These individuals do not benefit from political insulation. They either comply or they do not, and they carry their own risk. If they are blocked, they document it, and that documentation matters later. This is the stage where systems reveal themselves, not through speeches or rallies, but through paperwork, deadlines, and silence. That silence did not shrink. It expanded. That was when it became clear this was not just another delay cycle. Something structural had shifted. Institutions do not think primarily in terms of outcomes like charges or punishment. They think in terms of control. Control is exercised through process. There is a normal sequence when someone resists a court order. First comes accommodation, then narrowing. Only after that does enforcement appear. What stood out here was how quickly that sequence was skipped. The court behaved as if accommodation had already failed. That suggested a pattern, not an isolated incident. Patterns matter more than individual facts at this stage. Repeated delays, repeated appeals, and repeated arguments eventually cross a line. At that point, behavior starts to look like defiance. That line is not written down, but everyone inside the system recognizes it. Once crossed, treatment changes quietly but decisively. Another subtle detail mattered. The court did not direct Trump personally to act. It directed custodians of records. That was a containment move. It limited interference and isolated responsibility. It also shifted pressure onto people who were not protected by politics. This is where the human layer becomes important. Lawyers now had to give advice knowing contempt was explicit. Staff had to choose words carefully. Third parties had to decide between loyalty and liability. Those decisions happen in private conversations, not on television. Confidence drains quickly in moments like this. The court also did not signal concern about optics. In cases involving national figures, courts often acknowledge sensitivity. Here, the focus was narrow and functional, compliance. That suggested authority was being prioritized over perception. That only happens when judges believe authority itself is being tested. Once records are produced, analysis accelerates. Forensic review follows numbers and patterns, not politics. Investigations that stall for years can move rapidly once documents arrive. Delay had always been the buffer. Time had been the shield. This order removed it. There was no spectacle, no speeches, just a deadline that did not bend. Silence spread outward to donors, consultants, and allies. Waiting replaced commentary. Waiting itself became pressure. By the end of that phase, it was clear that the system was no longer negotiating. It was moving. The remaining variable was choice, compliance, resistance, or something in between. Each carried consequences that could not be undone. Inside institutions, responsibility fragments. Legal teams assess exposure. Administrative offices quietly ask procedural questions. Security teams think ahead. Not because they want action, but because they may need it. The assumption that enforcement would stop short had held for decades. This order challenged that assumption structurally. The court did not just say no. It said enough, and it removed the cushions. Resistance faded quickly. No immediate counterfiling appeared. That absence suggested that private advice had changed. Courts prefer compliance, but when delay persists too long, the priority shifts from accommodation to credibility. Once credibility is at stake, backing down becomes costly. People began speaking in conditional language. If compliance fails, if interference is documented. These were procedural signals, not political ones. The public narrative stayed flat because attention complicates execution. Silence simplifies it. As deadlines approached, options stopped expanding and started collapsing. Partial measures increased risk. Public defiance created intent. Advisors shifted from debating strategy to limiting damage. Communication slowed further, not because nothing was happening, but because everything was being documented. When people expect their words to be read later, they use fewer of them. At this stage, personal narratives stopped mattering. The system only cared whether orders were followed. Time became pressure rather than protection. From the outside, it still looked quiet. Inside, the shift was complete. The question was no longer whether authority applied, but how it would be exercised. That question does not reverse. What followed was not drama, but acceptance. Institutions resolve moments like this through inevitability, not confrontation. Paperwork moves, processes continue. Authority preserves itself through follow-through. The long-running strategy of delay ended not publicly, but privately. Delay only works when someone is willing to wait. Here, waiting had ended. These moments do not feel historic while they are happening. They feel procedural. Only later do people recognize the line that held or the one that was crossed. From here, events no longer wait for commentary. They proceed.